welcome to yet another edition, the 273rd edition of Legal Empowerment Through Interaction Lecture Series. Today, we have a wonderful speaker on a very controversial and I don't know whether the time constraints would permit us to go deeper and deeper into it, but still, I'm sure that we'll be able to cover the subject. We have Mr. Shrikrishna Dagliya. He's a senior judge, senior division, and presently he is the presiding officer of Labor Court, Jabalpur. And with us today, we have Justice Ramkumar sir, Justice Ramakrishnan sir, Justice M.V. Ramana sir, and all of you wonderful participants who have been part and parcel of this wonderful journey of empowerment, enlightenment, and interaction. Today's topic is contours of the power under section 156(3) CrPC. And the speaker will be leading the deliberations, the presentation, and thereafter we'll discuss about it. But before I hand over the platform to Prem for the introductory remarks, I thought it fit that there are two state amendments which I could see when I scanned this. So I just thought I'll just mention the state amendments because it's very interesting also. The earliest one is that of Maharashtra and the later one is that of Goa. 156(3), as you all know, is any magistrate empowered under section 190 may order such an investigation as above mentioned. The other things will be dealt with. I just go through the state amendments. The Maharashtra amendment states, that is Act 33 of 2016, provided that no magistrate shall order an investigation under this section against a person who is or was a public servant as defined under any other law for the time being in force in respect of the act done by such public servant while acting or purporting to act in discharge of his official duties, except with the previous sanction under section 197 of the Code of Criminal Procedure 1973 or under any law for the time being in force, provided further that the sanctioning authority shall take a decision within a period of 90 days from the date of the receipt of the proposal for sanction, and in case the sanctioning authority fails to take the decision within the said stipulated period of 90 days, the sanction shall be deemed to have been accorded by the sanctioning authority. This is the Maharashtra amendment by virtue of Act 33 of 2016. Now let us see the Goa amendment. Provided that before passing any orders, the magistrate shall issue notice to and hear the public prosecutor, government counsel, pleader, and the superintendent of police in the matter. That is Act 15 of 2014 with effect from 17/9/2017. With this sharing of short information, may I request Prem to do the introductory remarks, render the introductory remarks rather.
Well, today's topic, it's an extremely debatable one, which could be gone to very great depths. See, section 156(3) of the 1898 CrPC, that was literally lifted and placed as section 156(3) of the present CrPC. And as we know, that this is a section which is a single liner, which states that any magistrate empowered under section 190 may order such an investigation as above mentioned. So now, just before beginning this webinar, I just counted the number of words. Actually, it ought to be 13, but there are 14 words. Altogether 92 characters to be very precise. But it is capable of making you speak a million words in a single word. Now, mind you, the words may order such an investigation. See the words used, such an investigation, which is contained in this section 156(3). That has to be borne in mind while we are debating. Now, in this very small section, we have seen very erudite judgments ranging from the three judges, Devarapalli Lakshminarayan Reddy, which is a 76 Supreme Court judgment, AR 1976 Supreme Court 1672 with Justice Sarkaria. Then you have the off-quoted judgment in Chularam versus Kishore Singh, 77-4 SEC 459 by Justice Fazalali, if I remember. And of course, the judgment of His Lordship Justice Nariman in 2019, Vinubai Haribai Malavya, AR 2019 Supreme Court 2433, which the latest ruling, in fact, has given a very, very, very wide interpretation regarding the scope of application of 156(3), laying down a concept that the investigation under this particular provision, it would embrace the entire process, see the words used, which starts or commences from the collection of evidence and continues until the charges are framed by the court, at which stage the trial can be said to have begun. Now, long before Justice Nariman so held, I could lay my hands on a decision of the Kerala High Court during 1985. It was the judgment in Aravindakshan was the state of Kerala, 1985 Criminal Law Journal 1389, where the scholarly Justice S. Padman, he went on to hold that it is true that there is a provision in 156(3) of the CrPC which empowers a competent magistrate to take cognizance under section 19, as we see, or to order an investigation as provided in section 156(1), which would not indicate that the jurisdiction of the court in ordering a further investigation after taking the cognizance is barred by that provision. On the other hand, it was held that 156(3) only shows that the power to direct investigation is always there with the court. And we see after 156(3), the process begins with the registration of an FIR. Then you have the collection of evidence. And ultimately that has to end in a police report under 173 clause 2. Now 156(3) again was put under scanner in the Shakiri Vasu case, AR 2008 Supreme Court 907, where Justice Kajju, he spoke of 156(3) by holding that under 156(3) the magistrate holds the implied power to monitor an investigation, wherein he relies on the three-judgment decision of Justice Desai in JSC Sultana's case, AR 1980 Supreme Court 326. But to be very honest, I think this was quite a judicial overreach, because even JSC Sultana, to that particular point, went against another three-judge bench of 1970, S.N. Sharma versus Bipin Kumar Tiwari, 1970, Volume 1 SEC 653, which says no, the remedy of an aggrieved lies only in invoking section 482. Because that particular judgment, Justice Bhargava, who was speaking for the bench, he went on to hold that if you read section 156(3), the provision shows that the wise legislature, with all its wisdom, extended no further power to a magistrate either to control or to intercheck or to stop or give any directions to the mode of investigation. And the scheme of investigation postulates an uncontrolled investigation by a magistrate, which we have even during the Privy Council days. And seems these precepts, they have been relegated with variance in ever so many rulings. Likewise, you have Madhubala versus Suresh Kumar, AR 1997 Supreme Court 3104, which also gives a very interesting read. Later on, it was Priyanka Srivastava, 2015, 27, where the Supreme Court lays down that an affidavit has to be invariably filed along with an application under 156(3), for which you seek investigation, forwarding this complaint to be investigated by the police, which has been upheld by a recent Supreme Court judgment in Babu Venkatesh case, 2022 5 SEC 639. Quite interestingly, I had come across a very, very short judgment in Joseph Mathuri versus Swami Sachidanand, which is not reported in any leading law journals, but the citation is 2001, Volume 3, Crimes 384. It's a very short judgment. I had in fact shared the judgment with Justice Ramkumar, Justice Ramakrishnan, Justice Ramana, I think on the earlier occasion. We were speaking on this particular issue, where the Supreme Court went on to hold that even a mere relief prayed for in an application filed before a magistrate, even if the relief is forwarded to the police for investigation under section 156(3), that itself can be treated as a complaint. Now, how do you reconcile this judgment with the Priyanka Srivastava? I really don't understand. And yet another controversial facet is the question of sanction while ordering investigation under 156(3). Now, Shyam, he has taken us through two state amendments. One is of Maharashtra and the other one is of Goa. The Maharashtra amendment, almost it draws parallels with this Anil Kumar versus Ayyappa, 2013, volume 10, SEC 705, wherein it was held by Justice K.S. Radhakrishnan that without the statutory previous sanction, that's the case of the PC Act and sanction under section 19, a special judge, he cannot order for an investigation as against a public servant invoking the power under section 156(3). And this in fact was reaffirmed or reiterated in Manharibai Kakadia's ruling. That's a 2012 judgment, 2012 10 SEC 517. And please see, even with regard to this further investigation, Justice Sikri in Narayana Swami's case, 2016 9 SEC 598, he goes on to hold that an order directing a further investigation under 156(3) cannot be passed in the absence of a valid sanction. See the words used, further investigation, and see what was the first question which was framed in that particular decision. The first question, only two questions were framed, and the first question itself was whether an order which directs a further investigation under section 156(3) can be passed in relation to a public servant sans a valid sanction or contrary to the judgments in Ayyappa versus Anil Kumar and Manharibai Kakadia. Now, as of now, one of my learned friends he has put in the chat box, I could see that Anil Kumar versus Ayyappa was overruled by some other judgment he was saying, but that's not correct. In fact, Anil Kumar versus Ayyappa was doubted in Manju Surana versus Sunil Arora, 2018 5 SEC 557. It was doubted. And the Anil Kumar ratio, it has been referred to a larger bench. So a very important question now arises is, under section 156(3), if an order is passed, is it revisable? Is it an interlocutory order or is it an intermediary order? Which I would throw open for the participants to comment upon. Well, I could have gone on and on with this particular thing, but I don't want to stand in between you and the speaker of the day, Mr. Shrikrishna Dagliya, who is a very knowledgeable and erudite judge, who is so humble with poise, and he possesses a great zeal and enthusiasm to learn. And more particularly, he is totally unassuming, despite being a treasure house of knowledge. So, sir, the platform is all yours. Please.
Thanks, respected sir. Good evening, everyone.
Good evening.
I'll begin my address by reading the relevant provision, section 156, subsection 3. Any magistrate empowered under section 190 may order such an investigation as above mentioned. As sir said, it is just a one-liner, but a number of rulings have come on this point. To properly understand the scope of section 156(3), it is necessary to meticulously look into section 154, 156, subsection 1, and section 157. The reason is, under section 156(3), no parameters have been provided for a magistrate to exercise his discretion. So these parameters we will have to borrow from section 154, 156(1), and 157. Section 154 mandates that on intimation, on information given to a police officer, SHO, of the commission of a cognizable offense, he is obligated to register an FIR. This is the clear provision of section 154. Now, before the Constitution Bench judgment in 2014 in Lalita Kumari's case, there were two series of judgments. One line of judgment said that it is not mandatory for an SHO to register an FIR. He had discretion, and in which he could conduct a preliminary inquiry and refuse to register an FIR. Another line of judgment said that it was mandatory for him to register an FIR. This controversy was put to rest by the Constitution Bench judgment in Lalita Kumari in 2014 to SEC 1, wherein it was held that whenever an SHO is informed about the commission of a cognizable offense, he has no discretion in the matter, he has to register an FIR. A few exceptions were carved out in the ruling itself, wherein a limited preliminary inquiry could be held. I say limited because the scope of the preliminary inquiry, even in those matters enumerated in the ruling, was just to ascertain whether a cognizable offense is made out from the information received or not to test the veracity of the information. So Section 154 is clear that it is mandatory for an SHO to register an FIR. The Constitution Bench judgment in Lalita Kumari's case is also clear, which mandates an SHO to register an FIR on being informed of the commission of a cognizable offense. Now, once an FIR is registered, the power to investigate comes from section 156 subsection 1. This is the section which provides the power to an SHO to investigate a case. Now, registration of an FIR and investigation are two different things. For registration of an FIR, what is required is just information of the commission of a cognizable offense. But for investigation under section 157, a higher parameter is provided. The parameter is that the SHO must have reason to suspect that an offense has been committed. So these two distinctions will have to be borne in mind, because this provides the parameters for exercise of discretion under section 156, subsection 3 of the CrPC. Although section 156 doesn't specifically say so, but there cannot be two parameters, one for the police officer and another for the magistracy, to register an FIR and order investigation. Am I audible, sir?
Yes,
very much.
Yeah. So we go to the stage at which this power should be exercised. Now, to understand this, a distinction will have to be made at the threshold between two things: in cases which arise out of complaint and in cases which arise out of police report. If this distinction is not borne in mind, then the recent judgment in Vinubhai Haribhai's case is bound to create confusion. As early as in 1976, in the three-judge bench decision of the Supreme Court in Devarapalli Lakshmi Narayana Reddy versus V. Narayana Reddy, 1976, Volume 3, SCC 252, it was held that power under Section 156(3) could be exercised only at the precognizance stage. Now, what Vinubhai judgment, Vinubhai Haribhai Malviya versus State of Gujarat, 2019, Volume 17, SCC 1, said is that the power under Section 156(3) could be exercised even after taking cognizance, and a restriction was put on the power that it could not be exercised once the trial has commenced. The Vinubhai judgment in para 28 also stated that the finding in Devarapalli's case is not correct. So the irony is, Devarapalli's case was also a three-judge bench decision, and Vinubhai's case is also a three-judge bench decision. Going by the law of precedents, a later three-judge bench decision could not have expressed an opinion as law against the earlier three-judge bench decision. The proper course would have been to refer the matter to the CJI for further reference to a larger bench. But anyways, if we understand both these judgments in proper perspective, then the confusion would disappear, in my opinion. Devarapalli's case was a case instituted on complaint. The matter under consideration in that case was a complaint case, wherein it was stated that when a complaint is received by a magistrate, he has two options. Either he can proceed under Section 200 by taking cognizance. Once he takes cognizance, the power under Section 156(3) cannot be exercised. In complaint cases, the power under Section 156(3) could be exercised only and only before taking cognizance. This was stated in Devarapalli's case. The matter before Vinubhai's case was not a complaint case matter. It was a police report matter. So there was no need for the Vinubhai bench to hold against Devarapalli's case. In Vinubhai's case, it was held that in police report also, although it was not so held specifically, but if we go through the judgment meticulously, this is what is held in it: that in police report cases, even if cognizance is taken by a magistrate, then too, until the trial begins, he can order further investigation. Now, one more difference is there. I will come onto the type of investigations later. I would mention them briefly right now. There are three types of investigations. One is initial investigation, another is further investigation, and the third is de novo investigation, which is also referred to as reinvestigation or fresh investigation. So the matter before Devarapalli's bench was a matter relating to initial investigation. But the matter before the Venubai bench was not a matter relating to initial investigation. It was a matter relating to further investigation. If we go through the judgment, this is clear that it was a matter relating to further investigation. So, sum up, in complaint cases, when a complaint is received, before taking cognizance, only power under section 156(3) can be exercised. That is at the pre-cognizance stage. But in police report cases, the power can be exercised even post-cognizance until the charges are framed. Now, the law that has been laid down in Venubai's case, that only until charges are framed, the power can be exercised, is not in consonance with what the legislature had thought. If we look at the 1898 code, in section 173(8), section was not there. The power to further investigate was not there. By the 41st Law Commission report, it was recommended and suggested that such a power should be there with the police to further investigate the case even after filing of charge sheet. So this suggestion was incorporated in the present CrPC of 1973 in the form of section 173(8). So neither did the 41st Law Commission report envisage that there should be any restriction on the power of the police to further investigate, nor did section 173(8) specifically provide for any restriction. But Venubai's case limited this power only till the framing of charges. The power of the police under section 173(8) as well as the power of the magistrate under section 156(3) was limited in this case, only up to the framing of charges. Now, this there is a ruling of the Honorable Apex Court in Amrut Bhai Shambhu Bhai Patel versus Suman Bhai Kanti Bhai Patel 2017, Volume 4 SCC 177, in which it was held that the power of the police to further investigate a case can be exercised at any stage. In Venubhai's case, while holding that the power is limited up to the commencement of trial, no reasoning at all was given. What was said that it is quite obvious that such power cannot be exercised once the trial begins, and therefore this law was laid down. No reasoning was given in that. Now there are certain prerequisites. Before that, I would say that the power of investigation under section 156(3) can be exercised in two ways. One is suo moto and another on application. Whenever an application is made, there are certain requirements which are to be fulfilled before which the power cannot be exercised. Certain such requirements were laid down in the case of Priyanka Shrivastava versus State of UP 2015, Volume 6 SCC 287, and also in a judgment delivered by Honorable Madhya Pradesh High Court in Ramesh Tiwari versus State of MP, ILR 2014, MP 1404. In these judgments, it was held that before a person approaches a magistrate under section 156(3), he has to necessarily, before that, he has to necessarily go to the concerned SHO and pray for a registration of an FIR. Once an SHO declines or doesn't respond, he has to seek recourse to section 154 subsection 3. He has to send the substance of the information to the concerned SP. If both these formalities are taken care of and it doesn't really result, then only an application can be made to a magistrate under section 156(3). This was laid down in both these rulings of Priyanka Shrivastava and Ramesh Tiwari. Along with this, another requirement was laid down that without an affidavit, an application under section 156(3) would not be maintainable. Now, I'll again read the section and we will dissect the section and see the various nuances. Section 156 subsection 3 reads as follows: any magistrate. Now, what is meant by magistrate? In the Apex Court decision in Naman Singh versus State of UP 2019, Volume 2 SCC 344, it was held that the term magistrate doesn't mean an executive magistrate. The power under section 156(3) can be only exercised by a judicial magistrate. It was also held in the ruling, suppose a matter comes before an executive magistrate whereby he is informed about the commission of a cognizable offense, what is the course open to him if he cannot exercise the power under section 156(3)? The course open to him is that he can become the informant, he can go to the police and get an FIR registered, or he can also file a complaint. So the term magistrate doesn't include an executive magistrate. Now we go further. Any magistrate empowered under section 120. So the magistrate must be empowered. Only a jurisdictional magistrate can make an order under section 156(3), and the order can be made only to a jurisdictional SHO. We go further. Any magistrate empowered under section 190 may order such an investigation. Now, may order. This is, as Prem sir said, given rise to a lot of discretion, whereby some magistrates disallow the application and some allow the application. How is the discretion to be exercised is the moot question. In a recent judgment of the Apex Court passed last month, in the case titled XYZ versus State of MP, 2022, SCC Online, SC 1002, it has been held that although it is true that a magistrate has discretion under section 156(3), but that discretion has to be exercised judiciously. This matter went from the state of Madhya Pradesh. A complaint was filed before a magistrate along with an application under section 156(3). The magistrate, holding that an offense appears to have been made out, declined to proceed under section 156(3) and proceeded under section 200. The matter went up to the High Court. The High Court said it is the discretion of the magistrate. He can invoke any of these powers, either under section 156(3) or he can proceed under section 200. When the matter went up to the Supreme Court said, yes, there is discretion. But that doesn't mean the discretion can be exercised arbitrarily. The discretion has to be exercised judiciously. Now, there are certain rulings of various high courts that the power under section 156(3) should be exercised sparingly. I would cite certain such rulings. Sukhmani versus State of UP, 2007, volume 59, ACC 739. Tehseen Khan versus State of UP. It is a decision. There are certain rulings which say that this power should be exercised sparingly only when there is a need for investigation by the police agency. One such ruling is Ramesh Tiwari versus State of MP, ILR 2014, MP 1404. Another is Kaushik Roy Chaudhary versus State and another, 2011, volume 1, crimes 286. This is a ruling of Calcutta High Court. There are various such rulings, but according to me, these rulings do not lay down the correct law. The reason is no such restriction is envisaged by section 156(3) that the power should be exercised only in rare cases, or it should be exercised only where police investigation is necessary. If we go through the scheme of CrPC, twofold parameters are there. Whenever a magistrate receives an application under section 156(3), he has to be satisfied on two parameters. First, whether the information disclosed in the application discloses a cognizable offense. This is the requirement which we could trace to section 154, the same requirement which is there for an SHO to register an FIR. So the first parameter is whether the information discloses the commission of a cognizable offense. And the second parameter is the one which could be traced to section 157, power of police to investigate. The magistrate has to satisfy himself that after perusing the information, there are reasons to suspect the commission of an offense. If these two parameters are fulfilled, in my understanding, no other restriction could be placed on the power of magistrate to order investigation under section 156(3). There are various rulings of the Apex Court in which it has been held that investigation in cognizable cases, in cognizable offenses, is the primary duty of the police, and valuable time of the magistrate should not be wasted in proceeding in such cases under section 200. I would quote certain of such rulings. They are as follows. Chief Enforcement Officer versus Videocon International Limited, 2008, Volume 2, SCC 492. Gopal Das Sindhi versus State of Assam, EIR 1961, SC 986. Mona Pawar versus High Court of Judicature at Allahabad, 2011, Volume 3, SCC 496. Madhav versus State of Maharashtra, 2013, Volume 5, SCC 615. So in these rulings, it has been held by the Supreme Court that the primary duty of investigating in cognizable cases is of the police, and the valuable time of the magistrate should not be wasted in such matters by proceeding under Section 200. So the scheme of CrPC doesn't put any restriction on the powers of the magistrate, as have been put by rulings of various high courts, which have said that the power should be exercised sparingly. So we have on the one hand the scheme of the CrPC, and on the other hand we have rulings of the Honorable Apex Court, which say that the power should be exercised, as it is the primary duty of the police to investigate cognizable cases, and the valuable time of the magistrate should not be wasted in such cases. In one ruling, the Apex Court held that what is required to order an investigation under Section 156(3) is the bare reading of the complaint. If it discloses cognizable offense, order under Section 156(3) can be made. This is Srinivas Gundalri versus Sepco Electric Power Construction Corporation, 2010, Volume 8, SCC 206. Now the question is, as the language suggests, it is a discretionary power. When the discretion should not be exercised? According to me, it should not be exercised when it could not be conducive to justice. I would like to give a few instances. Suppose a person comes before the magistrate complaining that he went to the police didn't register an FIR in a cognizable case, and therefore he doesn't want the police to investigate the case. He wants that the magistrate should proceed under Section 200. In such cases, the magistrate should not suo motu exercise his power under Section 156(3) and send the matter for investigation to the police, because the aggrieved person fears that the accused and the police have come hand in glove with each other, and the police is not investigating the case because of some ulterior motives. So, according to me, whenever an application is made under Section 156(3), the power should invariably be exercised. But when the question is of suo motu exercise of the power, and the aggrieved person feels that the police won't investigate the case properly, the magistrate would be justified in refusing to send the matter under Section 156(3). Now, one more thing to remember is that generally it is the burden of the state to prove the guilt of the accused beyond reasonable doubt. So, if a person comes before the magistrate informing him of the commission of a cognizable offense and praying for an order under Section 156(3), and the magistrate doesn't order investigation under Section 156(3) but proceeds under Section 200, what he would be in effect doing is that the burden of proof of the state would be shifted upon the complainant. He would be put to great difficulty, and this burden is not a light burden, it is a very heavy burden, the burden to prove the guilt beyond reasonable doubt. So this would be unnecessarily shifted to the shoulders of the complainant if powers under Section 156(3) are not exercised. Now, there have been some rulings of the Honorable Apex Court which have said that whenever an order is made under Section 156(3), it should show that the concerned magistrate has applied his mind. A mere statement that the magistrate concerned has applied his mind is not enough. Application of mind must be clear from the order. To this effect are two rulings of the Honorable Apex Court: Ramdev Food Products Private Limited versus State of Gujarat, 2015, Volume 6, SCC 439. And this was also laid down in Priyanka Shrivastava versus State of UP, 2015, Volume 6, SCC 287. Now we come to the types of investigation. As I said earlier, there are three types of investigation which are possible. One is initial investigation, one is further investigation, and one is de novo investigation. Section 156(3) doesn't clearly speak as to which investigation it speaks about. But in the case titled Vinay Tyagi versus Irshad Ali, 2013, Volume 5 SCC 762, it has been held by the apex court that the power under Section 156(3) can be exercised only in reference to two types of investigations. That is, one is initial investigation and another is further investigation. Power under Section 156(3) cannot be exercised to order de novo investigation. This is a power available only with the constitutional courts. Now, who can be directed to investigate? Only the concerned SHO can be directed. The magistrate cannot direct any superior police officer, nor the CBI can be directed to conduct investigation. This is also clear by the law laid down by the apex court in CBI versus State of Rajasthan, 2001, Volume 3, SCC 333. Now, the power under Section 156(3) to order investigation doesn't include the power to stop investigation, meaning thereby that a magistrate cannot, by exercising this power, make an order to stop investigation which is ongoing. There is a ruling to this effect of the apex court in Prakash Singh Badal versus State of Punjab, 2007, Volume 1, SCC 1. Now, the power under Section 156(3) are very wide powers. These powers extend to ensure, to do anything which is necessary to ensure proper investigation. This was laid down in Sakiri Basu versus State of UP, 2008, Volume 2, SCC 409. That the powers are very wide was also laid down in the case of M. Subramaniam versus S. Janaki, 2020, Volume 16, SCC 728. This was also laid down in the case of T.C. Thangaraj versus Ingamai, 2011, Volume 12, SCC 328. There is a ruling of our Madhya Pradesh High Court in which it has been held that monitoring investigation and supervising investigation are two different things. Monitoring is a limited concept, whereas supervision is a broad concept. And what the magistrate can do under Section 156(3) is that he can monitor the investigation, not supervise it. This was laid down in Archana Devi versus State of MP, 2018, lawsuit Madhya Pradesh 2365. Now, this power under Section 156(3) cannot be exercised, as I said, to give the investigation to any person other than the concerned SHO. But what the magistrate can do is he can recommend change of investigating officer. This recommendation can be made to superior police officers. This was the law laid down in the case of Sudhir Bhaskar Rao versus Hemant Yashwant Dhage, 2016, Volume 6, SCC 277. This was also laid down in M. Subramaniam versus S. Janaki, 2020, Volume 16, SCC 728. Now I come on the right of hearing of the accused, concerned accused, prospective accused. It is clearly laid down by the apex court that the prospective accused doesn't have a right of hearing before an order is made under Section 156(3). The rulings are Anju Chaudhary versus State of UP, 2013, 6 SCC 384, and L. Narayana Swamy versus State of Karnataka, 2016, 9 SCC 598. Now, Shyam sir brought into everyone's knowledge that there are two state amendments, one of Goa in which the right of hearing has been statutorily provided to be given to the concerned SP and the public prosecutor. This is unique. And the Maharashtra amendment, as I was looking for it on ACC, I found that the amendment has not been brought into force. I may be correct.
I think it was challenged by a social worker, that is Pradeep Kumar Popatlal Vakaria, and it was dismissed for default on 13/3/2019, and the restoration application also dismissed on 23/2/2021. I think I don't know about it being, it was challenged, but that, and the final wording is, however, we make it clear that rejection of this application will not preclude any challenge which has been raised in the petition from being raised once again, provided there is a cause of action shown to be arising for making such a challenge by an aggrieved person. That is how the division bench finally concluded.
So as I can see on SCC, it is written that there is a state amendment of Maharashtra, Act number 33 of 2016, with effect from the date to be notified. So it appears
Act 33 of 2016, yes.
With effect from the date to be notified. It appears that it has not been notified and has not come into force yet.
2017.
Even without it being notified, it was challenged, I believe, before the division bench.
Is it 2017 one SCC 640 you are referring to? HDFC case?
Which case?
HDFC Securities.
No, sir, I am not referring to a case.
It is not HDFC. It is, in fact, what I was referring to was by this social worker, Pradeep Kumar Popatlal Vakaria versus State of Maharashtra through its Secretary, Principal Secretary, Ministry of Law and Judiciary Department, Mantralaya, Mumbai, and another.
Because Mr. Rao had posted in the chat box.
Yeah, that I checked, but I could not find anything. I was about to ask him later.
That's why I asked, is it 2017 one SCC 640? Actually, I don't know. I had read that judgment. I never thought of.
Yes, sir. Sir, this was challenged by HDFC Bank before the Supreme Court. And the Supreme Court held that prior sanction is not required. And also holding that into place in 2017, the Bombay High Court, Aurangabad bench in Vittal Rao's case overruled that, saying it is tried that 197 is only applicable when the actions are done in consonance with his duty. Not only that, sir, the amendment is dated 30th August 2016, notified in the Gazette, and I challenged it in 2018 before the ACCM in Bombay, and I got an order also saying that prior sanction is not required. Because the amendment is very clear, sir. It says the magistrate has to see whether the acts are in consonance with the line of his duty. So now what the Maharashtra government has done is laid the burden on the shoulder of the magistrate to decide and not the police. So I said, sir, I informed the judicial officer that now the onus lies on you. So she said, why should I take the onus? And so I said, yes, ma'am, it's not a blanket ban. So you'll have to look at it that way. And then she passed an order to file an FIR also against public servants, sir. This has happened specifically in my case, sir.
I think the Maharashtra one, we'll have to look into it, because what Rao sir said would be correct, because it is personal matter and things like that, but I could not find anything in the net.
So maybe on the...
No, sir, the Gazette is there.
No,
brought
like
into,
sir
has
said,
been brought into
has been
force.
notified.
Has it
Yes,
been
sir.
brought into force?
Yes, sir. And then I challenged it, sir, because the wording of the amendment is that the magistrate has to now decide. It is not for the police officer. The onus is now put on the magistrate. So I said this is burdening the courts further, because the original decision to file an FIR or no against a public servant lies with the police. The magistrate will only look at it when it comes before him. But now if it's going to be a blanket ban, then always you will have to come before a magistrate only. Because if you don't want to wait for the 90-day period, which Shyam sir spoke about also, we'll be wasting time, sir, on that. So that is how I've got around 6 orders after that, sir, in the state of Maharashtra. And the public servants have not taken the plea of this notification before the Bombay High Court under 482, sir.
Anyway, Rao sir, we may have to look into it, and definitely. Shrikrishna sir, could you please continue with your presentation?
Just 1 second, because we have, to clarify this doubt, we have an author with us,
Yes.
Asim Pandya.
Yes.
He's from the Gujarat High Court Association.
Definitely. Pandya sir, please unmute and
Father, sir,
your constructive input.
so he
Hello.
will Sorry for it.
Good evening to all.
Good evening.
Sir.
Actually, I'm just attending this lecture because Shrikrishna Dagliya is always following me and he has sent me a link. So I don't want to give any input today. I would just simply listen to him and I would appreciate his efforts as a young judicial officer.
Kelly, once again, my apologies. Yeah. Thank you so much, Doctor. Yeah.
So he must continue. I will ask any question at the end of the session if required, otherwise not.
Okay, sir. Let's continue.
Now, I would talk about the distinction between power under section 156(3) and that under section 202. The power under section 156(3) in complaint cases can be exercised only at the pre-cognizance stage, whereas the power under section 202 can only be exercised at the post-cognizance stage. This is one difference. That is the difference relating to the stage at which the power could be exercised. Another difference is relating to the purpose for which this power is exercised. Section 156(3), there is nothing before the magistrate. He has not taken cognizance of the offense. So, whereas if there is a complaint before him and he has taken cognizance, section 202 power is exercised only for ordering an investigation, the purpose of which is to see whether there are sufficient grounds in the matter to proceed or not. So one is after taking cognizance to decide whether there is sufficient matter for proceeding further or not, and another is before taking cognizance. Another difference is between the power of arrest. If an order is made under section 156(3), the police has the power to arrest. Whereas if an order is made under section 202, the police doesn't have the power of arrest. This was held in Ramdev Food Products Private Limited versus State of Gujarat, 2015, Volume 6, SCC 439. It was specifically held that the power of arrest is not there with the police when they do an investigation under section 202. As there is no power of arrest, it was also held that recovery under section 27 of the Indian Evidence Act cannot be made in such an investigation. Another question is whether the High Court can be approached directly under Article 226 or section 482 of the CrPC. This was answered in the case of Sakiri Vasu versus State of UP, 2008, Volume 2, SCC 409. And it was also answered in the case of M. Subramaniam versus S. Janaki, 2020, Volume 16, SCC 728. It was held that ordinarily, High Court should not be approached directly. The aggrieved person must be first made to go to the magistrate under section 156(3), and thereafter he can approach the higher judiciary. Now the question of sanction. As was said by Prem sir, in Anil Kumar versus M.K. Ayyappa, 2013, Volume 10, SCC 705, it was held by the Honorable Apex Court that without an order of sanction, an order under section 156(3) could not be made against a public servant if he has done some act in discharge of his official duties. Another case on the same point is L. Narayana Swamy versus State of Karnataka, 2016, Volume 9, SCC 598. The matter has been referred to the CJI for reference to a larger bench, while Manju Surana versus Sunil Arora, 2018, Volume 5, SCC 557. Now, when only a complaint is filed before a magistrate, the magistrate has the option to suo motu exercise the power under section 156(3). A specific application under section 156(3) is not required. Similarly, if an application under section 156(3) alone is made without making a written complaint, the magistrate has power to treat the application under section 156(3) as a complaint and proceed in the matter. Whenever an order is made under section 156(3), on an application which was filed along with a complaint. On making such an order, the complaint doesn't disappear. The complaint is very much alive. This was laid down in Tularam's case, Tularam versus Kishore Singh, 1977 for SCC 459. Also in case titled H.S. Baines, Director Small Saving cum Deputy Secretary Finance versus State, UT of Chandigarh, 1980, Volume 4 SCC 631. Now a very interesting judgment was passed by our Honorable Madhya Pradesh High Court, wherein I'll give the citation first. Om Prakash Sharma versus State of Madhya Pradesh and another. In this case, it was held that when an application is made under section 156(3) before a magistrate along with a complaint, and the magistrate makes an order under section 156(3), and nothing is received by him for a period of 60 or 90 days, as is provided in section 167 for statutory bail computation. This ruling has made it mandatory for the magistrates to proceed on the complaint by taking cognizance under section 200. This is a very unique judgment which I came across. Now in Madhubala versus Suresh Kumar, 1997 8 SCC 476, it was held that whenever an order under section 156(3) is made upon an application, that application or complaint automatically turns itself into an FIR. Now, what is the final order that has to be made by a magistrate if he is going to allow an application under section 156(3)? He should make two orders. One order should be for registration of an FIR, and another order should be for investigation in the case. Even if the first order relating to the registration of an FIR is not specifically made, it is implied in the order of investigation, because police cannot investigate any cognizable case without registering an FIR. Now, rulings related to this are M. Subramaniam versus S. Janaki, 2020, Volume 16, SCC 728. Suresh Chand Jain versus State of MP, 2001, Volume 2, SCC 628. And the order which should be made, I stated that two orders should be made. The relevant ruling is Madhubala versus Suresh Kumar, 1997, Volume 8, SCC 476. Now, I shall talk about two strange judgments. I would state the reasons why I call them strange. One is Priyanka Shrivastava versus State of UP, 2015, Volume 6, SCC 287. And another is Babu Venkatesh versus State of Karnataka, 2022, Volume 5, SCC 639. In these cases, it was held that whenever magistrate wants to exercise the power under section 156(3), he can go into the veracity of the allegations. He can verify the truth of the allegations. Now, this is something which the scheme of CrPC doesn't envisage. There is a prior ruling of a coordinate bench of the Honorable Apex Court in Anju Chaudhary versus State of UP, 2013, Volume 6, SCC 384, in this case, it was held by the Apex Court that magistrate cannot enter into the arena of merits when he's about to exercise the power under section 156(3). So, in one judgment, the Supreme Court says that the magistrate cannot enter the arena of merits. CrPC, the scheme of CrPC also doesn't envisage that merits have to be gone into. But these two rulings, Priyanka Shrivastava versus Babu Venkatesh, empowers magistrates to check the veracity of the allegations. This requirement is not there. If a person approaches a police officer to register an FIR and ask him to embark upon an investigation, what the police officer has to do is, first of all, he has to satisfy himself that a cognizable offense has been committed. And then, secondly, he has to satisfy himself that there are reasons to suspect the commission of an offense. Now, reasons to suspect, this is what is required. The police officer is not required to check the veracity of the allegations. This has also been laid down in the case of Lalita Kumari Constitution Bench judgment, that at the time of registering an FIR, the police can't go into the credibility or reasonableness of the information received. Now, what is the remedy available if an order under section 156(3) is passed one way or the other? there are various rulings which say that the power of revision cannot be excised. On the other hand, there are rulings to the effect that power of revision can be excised. I could not find a specific ruling of the Honorable Apex Court on the point whether an order under section 156(3) is revisable or not. But we could go through the locus classicus on the subject of revision in Amarnath's case and VC Shukla, and which could throw light on whether the power is available or not. According to me, as it affects the rights of the parties, important rights, therefore the order should be revisable. Sir, this is what I had to say.
Thank you, Shrikrishna sir. It was indeed wonderful. And regarding the Maharashtra amendment and the Goa amendment, during the deliberations, we'll definitely look into it. May I go directly to Justice Ramkumar sir for your comments?
I am totally confused. See, you have done a very excellent research, Mr. Shrikrishna. Wonderful research. But then, where are we leading to? 156(3), according to my knowledge, you can't file a petition just to forward the complaint under 156(3). Of course, if you file a complaint, you can make a request also. It may be forwarded to. It should satisfy the requirement of a complaint as defined under section 2D CrPC. In that complaint, you can make a request. Certainly, it is for the magistrate to exercise the discretion to forward it or not to forward it under 153 CrPC. And 156(3) also takes in not only investigation. Of course, in a police charge case, it not only takes investigation, but also further investigation. Supposing the police file a refer report saying that there's no offense made out, is the magistrate bound by that? No. Magistrate can order a further investigation under 153 CrPC. And Lalita Kumari, so far as regarding preliminary inquiry, I have my own reservations about Lalita Kumari. I had written articles also, because Lalita Kumari itself relies on so many rulings starting from 1964 Supreme Court onwards. Or rather, Sirajuddin has been upheld. What does Sirajuddin say? Sirajuddin said, see, SHO is going to register an FIR against a public servant. There may be so many disgruntled elements again for not public servant for not complying with their request, for not currying favors, for not showing any official favors. All of them will be only happy to prosecute him. Therefore, if an FIR is straight away registered, incalculable harm will be caused to the public servant. This is what the Supreme Court said. Therefore, the public, therefore, and in fact, we will have a separate webinar on preliminary inquiry itself. It has to consume 2-3 hours. Therefore, I have my own reservations about that part of Lalita Kumari, which said the scope of preliminary inquiry is only to examine the question as to whether a cognizable offense is a very well drafted complaint may show cognizable offense. Supposing the complaint is drafted, supposing the first information is drafted by a knowledgeable lawyer, it will definitely show that a cognizable offense is made out. But in reality, there may not be any cognizable offense made out. But the police are bound. Likewise, even where an unscrupulous police officer, he is bound by Lalita Kumari. He has to compulsorily register an FIR. But he has got the discretion to commence investigation. That has been left as it by Lalita Kumari. So Lalita Kumari says, notwithstanding the compulsory registration of an FIR, he has got the discretion under section 157 to commence the investigation. So if he is an unscrupulous officer, he will say, of course, I have registered the FIR because of Lalita Kumari, because information refers to a cognizable offense. But whether I should start investigation or not, I should have reason to suspect. I don't have reason to suspect. That aspect, Lalita Kumari should not have left as it is. Lalita Kumari should have said that if there is a information for regarding the commission of a cognizable offense, and if there is the allegations show that there is a cognizable offense committed, then no such further discretion should be given to the SHO. Otherwise, a intelligent SHO will register an FIR and then say, I am not going to commence the investigation because I am not satisfied. Well, so many confusion. According to me, anyway, I will hear the erudite members, and finally we will become more.
Sir, let us assume that the police officers refuse to file the FIR.
Yes.
Leave alone for a moment. Let us leave the public servants out. This is an FIR against cognizable offense committed by certain individuals.
Okay.
They don't file the FIR.
Yes.
If 156.3 is not there, then what is the remedy left for me?
Exactly. 156.3 is the remedy. You can't go to the Supreme High Court with a writ petition. Writ petition will not be entertained. The remedy is 156. I don't say that 156.3 should not be there in the statute book. It is capable of being misused. That's a different thing. Anyway,
that is why Lalita Kumari goes and says that if it is a false complaint,
yes,
action can be initiated against the complainant, whatever. So I agree with you that the person will have to undergo the trial to exonerate himself. But sir, we all are going through it. At least I am going through it even now, and I'm not really committed the crime. But then the fact remains is that if it is not done, then we'll have a problem, sir. So that is now, if you see today the courts are burdened with 156.3 because police are refusing to file FIRs even when evidence, sir, in parliament they have admitted that certain things have happened, and the police says, but I will not file an FIR.
It is all because of the distrust in the police. Distrust in the police. That is why the Supreme Court was compelled to say that once there is an information regarding the commission of cognizable offense, you have to compulsorily register an FIR.
But still it is not happening today, sir.
Exactly. Even if it is registered, can he not say that I don't have reason to suspect the commission, the cognizable offense? Even relying on Lalita Kumari, he can.
Correct, sir. He can say that.
That loophole should not have been left as it is, according to me. Anyway, it's all for the erudite members to.
Perfectly.
Yes, thank you.
So what I'd request is that before we open up for deliberations, we'll hear the comments of Justice Ramashan sir, Justice Ramana sir, Asim Pandya sir, and then we'll open up. So Ramashan sir.
So as far as section 156.3 is concerned, the wording doesn't give any room for any confusion. Because when a complaint is filed before the court and the court is satisfied, some investigation is required, or if they feel that the detailed investigation is required, automatically it can be sent for registering an FIR and commence investigation. Once the court sends under section 153, I don't think that the police officer has got any other discretion to register an FIR and not to commence an investigation. He has to do it. But by virtue of the decisions, as Krishna as well as Brother Ramkumar has said, there are confusion as to whether it will have done or not, whether further discretion will not be the police officer. See, once you register an FIR, there is a subjective satisfaction that an offence has been committed and there is a suspicion of
Exactly. But 156,
thereafter,
under 156.3, there is no discretion.
No.
Because 156.3, you are forwarding it for investigation. So he cannot say that I am not
no discretion. He has no discretion once.
154, after registering an FIR under 154, under 157, he can say, I don't have reason to suspect.
No, there also, he can only, after collection of evidence, he can file a report, refer report. He cannot say that I will not start investigation. Can it be possible? No, I don't think so. See, once you register an FIR on the basis of a complaint or an oral statement that has been reduced into writing under section 156, 154, automatically you have to conduct an investigation. Then your remedy,
that's not what Lalita Kumari said.
No, Lalita Kumari, if you read the entire thing as a whole,
let me just point out that even after registration of a FIR, police has still discretion not to investigation under section 157 clause B.
Yes.
And then if he supposes refuses, then in that event, section 159 provides for remedy. He can make a complaint that despite registration of FIR, he has not commenced investigation. And in that event, under section 159, magistrate can examine this grievance.
Preliminary
So
inquiry.
Yes, yes. And so far as preliminary inquiry, Justice Ram Kumar said, there are a lot things to say about it. First of all, before
I was
judgment
saying,
of Lalita Kumaris,
I was mentioning about preliminary inquiry under section 159.
No,
159 also contemplates preliminary inquiry by
I
a
am just
magistrate.
talking about the requirement of holding preliminary inquiry before registration of FIR. That is contemplated in Lalita Kumari. That is, before Lalita Kumari, there was no such judgment except one judgment of Supreme Court in Bhagwant Kumar Joshi, I think versus then 1964, probably page 223, where it was held that Bhagwant Kumar Joshi's case.
That is 64.
64. And most important aspect is what is the extent of preliminary. Let us assume that the court has authorized preliminary inquiry, holding of preliminary inquiry. But what is the extent? In the garb of holding preliminary inquiry, statements are recorded of even accused or persons who may ultimately turn out to be an accused. So in that event, if it is registered at the stage of preliminary inquiry, it has no protection of Article 20, sub-Article 3 or Section 161, 162. So these are the things which will have to be pondered over, and for that a separate webinar, as you suggested.
Exactly.
That
it may be an investigation. Subject. It may be an investigation in disguise.
Yes, yes. It is, yes. So what has been stated in Bhagwant Kumar Joshi, that it has to be a discreet inquiry. You cannot call a person to police station for recording his statement under preliminary inquiry. Statement can be recorded only after investigation starts, after registration of the FIR, and that too only under 161, 162. Otherwise, all protection will be absolutely meaningless. Article 20, sub-Article 3 would be redundant in such case.
You're right. Justice Mudolkar only said just a verification.
Yes, discreet inquiry. So nobody should be called at the police station. That is a major concern today. In every preliminary inquiry, witnesses are called, even accused are called, proposed accused, and their statements are recorded. And that would be binding because he is not an accused on that day.
Sir, even under 202 today, the police are calling everybody and recording statements, which is not permitted otherwise also.
There the bar under 162 is not applicable. And it will not end in a 173(2) report.
Yes, yes. That's a different thing altogether. 202 statements are different because as Ramdev Food says that no arrest can take place, no discovery or etc. under section 27 is permissible under 202 inquiry. But let me just congratulate Mr. Dagliya because he is a very enthusiastic judicial officer. I admire him for writing so many articles. He has a great thinking process. So I congratulate the persons who have invited him to speak on this subject.
Thank you, sir. So now let us directly go to Justice Padman for his comments.
A good effort, Mr. Shrikrishna. You have undertaken a good lot of research and a simple provision. I think only one sentence provision has led to so much of discussion. And as Justice Ramkumar said, it is contributing to a lot of confusion, but at the same time, it is for us to get clarified, okay, on every aspect. You have done a good effort, okay? Congratulations. I don't want to say anything more than this, Prem. I don't want to add to confusion.
Thank you.
Make it confusion confounded.
Now let us go to Mr. Vikas Sri Sant.
Hello, good evening, sir. Thank you very much for such a wonderful judging, sir. My question is, sir, when a complaint is filed with some evidences under 156(3), but honorable judge directed to proceed under section 200, and same complaint was dismissed in revision, saying that although cognizable offences are made out, but he has to see look after only whether that order is legal or not. That means order part in the 156(3). And High Court also issued a notice in that case. So if although there is no any stake, if preliminary evidence is recorded, then that High Court petition will be infructuous. What should be done in such situations?
Sir, I didn't get your question.
Because actually we couldn't get your question. You're asking whether it was a fit case for a magistrate to forward for investigation police, but he proceeded under Chapter 15. The matter has been taken up to the High Court. In the meanwhile, sworn statement has been recorded. Is it that what you wanted to ask?
Yes, sir. Yes, sir.
Voice is breaking.
Truncated. I'll do one thing. You just reconnect and come back. We will take the question then. Now let us go to Dr. Srinivas.
Good evening to everyone, sir. Sir, my doubt or my question is whether the Vinubai case has anywhere dealt with section 173 clause 8 of CrPC. Why don't we think in that?
Yes, it has dealt with. It has dealt with.
Then my doubt is whether it is only on that particular point or also when the question is not about 156 class 3, it has unnecessarily poked into the decision of Jabalpur case. This is my observation, sir. As Shrikrishna sir rightly pointed out, that case deals with the police report. This case deals with the private complaint. So precognizance even after cognizance 173 clause 8. Whether the magistrate is having power to order further investigation or whether the 173 clause 8 is only restricted to the police powers. If we think in that way, I think that the confusion will be little less. I think, sir. I want your opinion or something.
No, what the power of the police to conduct further investigation is 173(8) only. After the initial investigation and after the filing of the charge sheet. Whereas the power of the court is under 156(3) only. That is why Justice Thomas in that Hemant Dushmana's case, Justice K.T. Thomas held that even though the court is ordering further investigation under 173(8), court is only triggering into motion the power of the police. It is the police power which the court is triggering into motion by ordering 173(8) CrPC. Hemant Dushmana versus CBI, AR 2001 Supreme Court 2721 Justice Thomas. So actually the powers are separately given, one for the court and one for the police.
So, Ramkumar sir, see, with regard to this question from Dr. Srinivas, I'll just take 1 minute. I'm a very great fan of Justice Nariman, who according to me, who is the greatest lawyer as well as the greatest judge to have ever walked in our country, whom I adore and admire so much. Equally, I do admire and adore Justice Ramkumar also. And here it is, my two heroes conflict. Now, in fact, Justice Ramkumar had penned an article against Vinubai, but almost, of course, he wrote it was a very welcome step.
Yes.
In my limited knowledge, now Justice Nariman's ruling, as Dr. Srinivas has pointed out, that seems to have overlooked a particular factor. See, under 156 clause 1 of the CrPC, you can see 100. So that's in consonance 156.1. 156.1 of the CrPC would say that any officer in charge of a without the order of the magistrate investigate any conflict which are not having jurisdiction over the open area within the limits of such statute would have power to inquire into or try under the provisions of this law. Okay, well, now if we see by virtue of 156.3, what does 156.3 say? Any magistrate empowered under section 190 may order such an investigation. See, this is why I pointed out the word such an investigation.
Yes.
As above mentioned. Now kindly see, why Justice Nariman went on to say, because it is here we need to go through which clearly observes that an order of 156.3 that is in the nature of a peremptory reminder, or rather an intimation to the police to exercise your powers of investigation under this 156.1 CR. And with the greatest respect, I think this particular point was not adverted in Vinubhai, because I still have a sense of feeling, of course. With my limited knowledge, I cannot visualize what the legendary Justice Nariman put with his immense wisdom, because such an investigation here, it was not 2H, which the legislature was referring to, but 156.1.
Yes.
Because when he went on to say Devrapalli did not consider 2H, and thus he almost, it's not distinguishing, almost he said it's not a good law, as good as overruling. I think there is slight confusion in this thing, because fortify myself, to defend myself, I can even quote a 6 benches decision versus Union of India, AR 1963, Supreme Court 1241. Chief Justice Sinha speaking for the bench was holding that the intention of the legislature, it could be best assembly by directing attention not merely to the clauses constituted, but to the entire statute. You have to compare that clause with other parts of the law, and then the setting in which that clause is to be interpreted occurs. It was not done. It's my humble take on this particular thing. Now we have Vikas again. Vikas.
Am I audible, sir?
Yes.
Sir, my question is, one complaint was filed before a magistrate under 156.3 with some evidences that makes out a cognizable offense. But same was dismissed and he proceeded under section 200. After that, that was challenged in session court, where they said that yes, cognizable offenses are made out as per this document, but he has to see only legality of that order, whether that order part under 156.3 are legal or not. After that, that was challenged before High Court, and where the notice is issued to all the parties in the state of government. But as of now, whether complainant had to give evidences, I mean preliminary evidences in lower court, or how can he proceed now? Because that case will become infructuous where notice is issued by High Court.
First of all, let me ask you one thing. 156.3, the order of 156.3, that was challenged by way of a revision in the Sessions Court, right?
Yes, sir.
How can there be a revision? 156.3, it is neither a final order nor an intermediate order.
Prem sir, you mistaken.
Yeah, that was.
I will tell you one thing, because of course we have right from Amarnath, we are having ever so many things. Of course, the right at the moment, right of the moment, whatever that be. Now, this is where that HDFC Securities case. Kindly see the Supreme Court judgment in HDFC Securities. HDFC Securities case, that was a 2017 judgment of the Supreme Court, 2017, 1 SEC 640. The Supreme Court said that 156.3 CrPC an order regarding investigation on 156.3. That can never be said to cause injury of any irreparable nature, because at the stage of cognizance would arise only after investigation. Only after the investigation, a report is filed by the police before the concerned magistrate. And on this particular ground, the Supreme Court went on to say that challenge to an order under 156.3 is nothing but premature.
Correct.
Right? When the Supreme Court said, see, either there should be some order, something should be there at that particular point of time.
And you have to be aggrieved to against that order.
True. And that is why even 156.3, kindly see, the dichotomy lies in 156.3, if it is revisable, the same Supreme Court says 156.3, you need not even give reasonings. Without reasoning, how are you going for a revision? That's it. Of course, discharge also, same thing would apply. Framing charge also.
Correct.
High Court already notice issued to all the accused persons.
Yeah, because once a notice is issued, the lower court will stay its hand till the notices are returned.
Not if no stay is granted.
No stay is granted, the trial court can proceed. Even if stay is granted, also the stay cannot be more than 2 months. The Asian resurfacing judgments for 2000 became clarified by another the 3 judge in 2020.
Correct. Rohinton Harriman again.
Clarified again.
Yeah, Asian reroad surfacing order.
Resurfacing. Now let us take the question of Mr. Sudhansh. Sudhansh, please unmute. I'll ask you to unmute. Mr. Sudhansh, yes. Okay, then I think there is one question in the chat box. One Prashant Rairo. The magistrate should apply. No, by.
Sorry.
Okay. Come on.
My mic was not unmuting. I am really very sorry.
No problem.
I have two queries. From to the speaker of the day, Mr. Shrikrishna Dagliya, sir. Sir, first of all, really thank you for this wonderful presentation. My question is, sir, that you have said that there are 2 judgments of the Honorable Apex Court of 3-judge bench, which are contradictory to each other. Can you please explain directly and to the point that which law exactly prevails in the present time regarding section 156(3)?
Yes.
If we compare both the authorities that you have told us, the earlier one and the second one, which was
as per the law,
second one, which distinguished earlier one.
As per the law of precedents, the formal ruling of a coordinate bench prevail. A subsequent coordinate bench cannot rule against the law laid down in the by the former coordinate bench. I had referred to Devarapalli's and Vinubhai's case. Actually, the problem was that Vinubhai's bench did not, according to my humble opinion, understand law laid down by Devarapalli's bench proper perspective. Otherwise, there is no conflict. One speaks of the exercise of power in matters relating to complaint, and one speaks of exercise of power in matters based upon police report. One relates to initial investigation and another talks about further investigation. So if we keep both, 2 of these differences in mind, it would be very easy to understand and reconcile both these judgments.
What about Ramdev? That is also 3-judge bench.
Yes, Ramdev is a 3-judge bench. Ramdev also.
I have one more query, sir. Shrikrishna sir, you later on you said that according to your personal opinion, there are 2 things that a magistrate should consider while passing order on an application under section 156(3). The first thing was that whether the offense alleged to have been complained is a cognizable or not. And what was the second thing, sir? Sorry, I was not able to hear that.
The same requirement which is there in section 156, reason to suspect the commission of an offense. Because there are not no separate parameters provided in section 156(3) for exercise of power. We have to borrow the parameters which are there with the police.
157.
Fire under section 154 and for investigation under section 157.
No, sir. My specific question is that you directly said that the magistrate has to consider 2 things. First thing is that whether the offense is cognizable or not, and second thing I was not able to hear. So therefore, I wanted to know that what was the second thing that the magistrate should consider, because it will be helpful for us to draft the application.
Sir, the second parameter is reason, whether the magistrate has the reason to suspect out of the information which he has received that an offense has been committed or not. This is what I said.
Okay. Okay. Thank you. Thank you.
But does it apply in the 156.3 order?
Otherwise, there are no parameters, sir.
See, 156.3 itself says shall order an investigation.
Yes, sir, I would like to bring
not order the SHO to file a register an FIR. It is ordering an investigation which presupposes the registration of an FIR and the commencement of investigation. Can the SHO say that no? Even though this is an order under 153, I have got the discretion under section 157. I don't have reason to suspect. Can you say that?
So he can't say.
He can't.
So this magistrate must on both these parameters. One, whether information discloses the commission of a cognizable offense. This is the first parameter. And second parameter is whether he has reason to suspect the commission of an offense. This parameter would have been applicable to police had the matter went to the police first. Now, as the matter is before the magistrate and he has to exercise his powers, and there are no specific parameters provided. So we will have to borrow these parameters which are there for the police.
But once the magistrate orders, can the police officer say, I will register an FIR, I should have reason to suspect the commission of a cognizable offense. 156.3 says order an investigation, not order an FIR to be registered.
SHO can't say, sir.
Investigation means he has to conduct an investigation. That is what that Madhubala said, I think. Madhubala, there are other rulings also. He has no discretion in the matter. He has to conduct an investigation. He will have to treat the complaint as the FIR.
That is Madhubala versus Suresh Kumar.
Madhubala.
The complaint becomes the first information statement.
First information statement, and he has to enter on investigation. He doesn't have the discretion under section 157. In a case which has been forwarded under 153.
Certainly.
Now we have a advocate pair. Please.
Hello, sir. Sir, my question is the 202 subclass 3. Whether the investigation conducted by the police officer, other than police officer, has no arrest to accuse, has no power to arrest accuse.
Police officer also.
But mere reading of section 202(3), if an investigation under subsection 1 is made by a person not being a police officer.
You are right. You are right. Police officer is exempted from that bar. He has got the power.
Income tax officer, drugs and customs officers, or other officers.
Even an advocate. Even a private person, advocate. Any person.
But the Supreme Court ruling
that goes against. You are right. That goes against the wording of the section.
Yes. My one more doubt, sir. Whether the 202 inquiry under section 202 inquiry conducted by the police, whether the proposed accused were participated.
No, they cannot. You read the comments in the criminal manual itself. It says the accused.
Only the victim and complainant alone may participate.
No, even the complainant need not participate. The officer has to read the complaint and only discern whether cognizable offences are made out in the complaint or no.
Okay. In one case in Chennai, under 202 inquiry, the police officer sent a summons.
No, he cannot send a summons, sir. Sir, that is why I am saying that is.
Can he not conduct an investigation? Though not under chapter 12.
Yes, he can.
He can conduct an investigation to enable the magistrate to decide whether he has got sufficient ground for proceeding further.
Lead to the magistrate.
Exactly. So that is why Prakash Chandra Dev and after that Nagawa came and said that the accused cannot come. It is just to
No, see, all those are investigation under another chapter, chapter 12. Now, this is not under chapter 12. That is why interdict under 162 won't apply. Because it says it shall not apply to an investigation under this chapter. That is chapter 12. That interdict cannot be imported to 202. Because chapter 12 investigation is separate. This is an investigation under chapter 15.
Viju Purushothaman.
Correct, Viju Purushothaman.
202 investigation means the police can even take signed statements, and that when during trial those statements can be you made use of not only for contradiction but also for corroboration.
Correct. As if it is like an FI statement.
Any other previous statement.
Any other previous statement. That's the difference between the investigation under 202 and the investigation under chapter 12.
Chapter 12.
So the interpretation of section 162 cannot apply because 162 uses the terminology investigation under this chapter.
This chapter.
See the wisdom of the legislature. They have forced.
One more interesting fact. Here, the application filed under section 156(3) to registration of FIR before the jurisdictional magistrate here in Hyderabad. The court given direction, Premraj case was made out, and given a direction to the SHO, local SHO, to make preliminary inquiry, and thereafter apply Lalita Kumar judgment. This is the order, judgment. Within 3 months, the report may be submitted to the court. This is an order. The police officer after receipt of the order of the jurisdictional magistrate, they sent a summon and conducted an inquiry and closed. The complaint was closed and sent back to the judicial magistrate. Again, one more application filed by the victim. We come under section 153 since my complaint was
yes.
So you are
not audible.
So cannot. Therefore,
there is some. Your voice breaks. Voice breaks.
The victim complaint or cognizable offence was made out. Therefore, the application under section 156(3) was maintainable.
Yes.
Even after given necessary appropriate direction under 156(3) to registration of FIR, without doing so, they went for investigation.
It's illegal.
We didn't get you.
Without doing so.
You see, there is an order under 153.
Yes, sir.
Then
there
FIR is.
There is a specific order.
Then he has to register an FIR. He has to register an FIR. Not registered.
No, sir.
Not registered. Without registration of FIR, they are sending. They are sending someone and call the witnesses and taking evidence and giving clean sheets to the accused.
Complaint can be treated as FIR. Nothing wrong. But he will have to register an FIR because for the purpose of record, at least.
Yes.
Police station record.
Obviously,
but then
what will happen?
See, so after investigation, he can definitely file a refer report saying that offence is not made out.
Obviously. There is a specific provision to file a negative report.
Yes.
And the victim has a power to file a protest petition also.
Exactly.
But without registration of FIR, the investigation conducted and given a negative report. And thereafter, the victim went to the 482 before the High Court. The High Court given liberty to file a protest petition in a CSR, in a summon inquiry stage.
Let us not be so hyper-technical. The complaint itself becomes the FIR, automatically gets converted. That is what Madhubala said. It gets converted into an FIR. Of course, for the purpose of record, the SHO should have made a number. It should bear a number, FIR number. Find a place in the FIR book also.
Correct. The station diary report.
Exactly.
Somewhere they are doing like this about it. Anyway, thank you so much.
And in fact, your question raises another issue. In all these special judges under the vigilance, under the PC Act special judges, I have noted one important thing. See, when a complaint is forwarded under section 156(3), SHO will either directly or through some other officer will conduct a preliminary inquiry, and based on the preliminary inquiry, he has got the freedom to register or not to register the FIR. But very often there are some judges here in Kerala, I know, that they will order, while ordering 153, conduct preliminary inquiry and report. So they will sit in judgment over the preliminary inquiry report, and they will decide whether the FIR should be registered or not. Is such a freedom, can such a freedom be taken or arrogate? Can the judges arrogate to themselves this right? Right to decide on the preliminary inquiry report. It is for him to conduct the preliminary inquiry, and on the result of the inquiry, he may either say that no offense is made out, though cognizable offense is alleged, actually no offense is made out, therefore I am not registering an FIR. And the aggrieved person, he will have to be given notice and he will have to work out his remedies. Instead, the judge himself is arrogating to himself the power to decide whether FIR should be registered or not. Is it a good practice? I am putting it for the floor to discuss.
He's going beyond his powers, no, sir, under the statute. Can he violate the statute?
That is happening in some of the courts here, some of the special courts.
To bring it to their notice, because if you go by the Constitution bench in Supreme Court Bar Association versus Union of India, even under Article 142 plenary powers, the Supreme Court says no court has powers to go beyond the statutory provisions. Yes. So we'll have to remind him of the same again, sir, which I am doing every day today.
No, it is not only the Supreme Court Bar Association. Starts right from 1958.
Yes, sir. Yes, sir.
Which A.R. Ampule, then followed again by Justice Venkatachala, Union Carbide. Then comes the Supreme Court. Then you can see Rupa Chopra. There were so many judgments on that point. And this particular Lalita Kumari also, even though it was a constitutional bench decision. Now, there is another judgment by Justice Nageshwar Rao and Justice Hemant Gupta. State of Telangana versus Sarveshwar Reddy. Where the Supreme Court goes on to say, what is meant by preliminary inquiry? What is the purpose? It is only to screen a wholly frivolous complaint.
Correct.
That is in furtherance of acting fairly. And the Supreme Court goes on to say that was a case where an FIR was sought to be quashed for the reason that the preliminary inquiry was not conducted. And the Supreme Court went on to say that the preliminary inquiry which is held in Lalita Kumari, that is not going to be mandatory conducted in all corruption cases. In this particular judgment, 2019.
So were they not going into the veracity of the complaint? According to me, that should be the order. The police officer should be able to consider the genuineness or veracity of the complaint before registering the complaint. That is what Sirajuddin said. And Bhagwan Singh also.
Correct.
64 Supreme Court also. It has been, in fact, prior to Lalita Kumari, there is a two-judge bench by Justice Sadashivam and Dr. Chauhan, both of whom were parties in the Constitution bench. They said that this is the law laid down. That I don't remember the citation. Prior to Lalita Kumari, they said that Sirajuddin is the law laid down by this court. Any officer or any court violating that will be hauled up for contempt. Not only that, this is not a curable irregularity, it is an incurable illegality. They said, same judges sitting in Constitution bench held that purpose of inquiry is only to find out whether cognizable offense is not or is there or not. I have my own reservations about that, with due respect.
Sir, even in Anil Kumar versus Ayyappa, Justice Premraj said one thing in one judgment and he went against it in another judgment. We had the same issue there also, sir. That is why Justice Chalmeshwar then read whether 156.3 could be, which was read with the PC Act, whether 156.3 can be read with any other act. And that is why I referred it to a larger bench.
And Anil Kumar, is there not a contradiction? Anil Kumar says, before, if it is a public servant, before forwarding the complaint to the police under 153, you have to obtain the prosecution sanction. You are sending the complaint. You are sending the complaint for what purpose? For investigation. The sanctioning authority can look into the investigation file only. Sanctioning authority can only look into the file of investigation. Investigation is yet to happen. You are forwarding the complaint for investigation. Then which material will the sanctioning authority look into?
And also it goes against Mata Jog Dobe versus H.C. Barina.
But there again, one confusion is there. Supposing it is a private complaint. Yes. He doesn't have the power to conduct the investigation.
Correct. So now let us go to Advocate Dilip for his.
Good evening, everyone. This is something which I don't think I will be able to
contribute much.
Contribute much.
You have always been contributing.
But only one or two points which I like the speaker was saying that 156(3) doesn't take in executive magistrates, or there are decisions stating that the executive magistrates are beyond or cannot exercise the decision under 156(3). But that is obvious from the section itself. Only a magistrate empowered under section 190. So the question of executive magistrate doesn't arise. Then here, when I went through 156(1) and 156(3), what I apparently took note is that 156(1) says that the police officer, even without an order from the court, can investigate into a cognizable offense. Because cognizable offense is made known to or informed about, he can investigate. So the only condition is that there should be a court which can try or inquire into the offense within the local jurisdiction of the police station. That alone is the criterion, because a police officer is empowered to investigate into a cognizable offense if he comes through he gets information of it, and then he can either drop the complaint or say that there is no offense committed, or if at all committed, he can send the report, register the FIR, then send it to the magistrate, then report also he can send it to the magistrate. The only 156 only says that a magistrate can also empower, and a magistrate can also direct into investigate. So subsection 2 also is relevant in this, because no proceedings of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section 2.
Yes, that is because if he did not have the territorial jurisdiction to investigation, still if he has conducted investigation, his power shall not be questioned.
So a magistrate, 153, if he is considering a private complaint under section 190, he can direct the investigating officer or the police SHO to conduct an investigation. That alone, I think, is much a confusion. I didn't make out from reading the section. Thank you. This much only I can say.
Okay, so I'm having a message of Justice Ramakrishnan that he has left. I'm leaving as I am having some commitments. The deliberation is healthy and informative, and congrats to the speaker who has made a good research on the subject. And well, I have to say that the speaker of the day, it is a very brilliant, erudite articulation of this particular provision, because you have made a very extensive research, citing almost all the judgments, leaving no stones unturned. And of course, you had traveled through the entire nook and cranny of this particular provision. And this was absolutely, it was a very, very healthy debate. We got a lot of learning. And now I would call upon Mr. Rao to say some words with regard to winding up of this particular session.
Now, Mr. Shrikrishna can share his notes so that the lawyer community can benefit. If you have got a notes with you, you can share it to the group, so that the lawyer community can be of great. It can be of great help to the lawyer community, practicing lawyers.
Good evening, everybody.
Good evening.
I'm really thankful to Justice Shrikrishna and the Letils platform for raising this subject, because this is a subject that goes to my heart. I'm not a lawyer, but I'm a litigant, and having exposed corruption in so many places, 156(3) has always been the only resort. left for me thanks to political interference or whatever. And today's subject is so clear, so lucid that there's nothing left to imagination as far as what the courts have laid down. As individuals, we all had our opinions, we all had our interpretations, and that is what is very healthy on this platform. And like I said, and I always say, I'm a candle before Premraj sir and the rest of you, because exhaustive knowledge is there with you, and Premraj sir though is an encyclopedia, so I need not say much on that. But sir, 156.3 is a conundrum that will never be come to a fruition at any point of time, because every magistrate tends to interpret it in a manner that leaves only scope for further litigation. And in fact, like I have at numerous times told the honorable judges, the justices, the judicial officers, that if cognizable offences are made out as held in all, including Anju Chaudhary, which refers to Khwaja Ahmad, Emperor versus Emperor, that statutorily cognizable offences have to be investigated by the police. So can the magistrate suo moto convert a 156.3 application into 200 and then go through the procedure and lay the burden on the litigant to provide evidence? Because there are certain documents which are not in my possession. I can give you a few documents, but I can't get you all the documents. Like recently the Jammu and Kashmir High Court held that unless specific allegations are made, 156.3 order is not to be passed. Now, if I have to make specific allegations, either I have to be part of the conspiracy, because I will not be able to, I know for a fact that an offense has been committed, but what is the role of each individual? I wouldn't know. It would be difficult for a complainant. It is like for me, I have seen a body on the floor, is dead, so I called the police. Now, if you say that I have to specify who murdered him, at what time, what was the weapon, it will be difficult for complaints to be filed in the first place. I do agree that, frivolous, like Justice Ramkumar said, there are a lot of frivolous complaints against public servants by disgruntled elements. I'm totally in consonance with what he says. But the fact remains is that how many of them are genuine also have to be noticed. Like I have a document where in Parliament they have admitted of the scam. But still the magistrate says, no, I will send it for a 202 inquiry. Then where does the litigant go?
That doesn't serve the purpose.
Yeah, exactly. So, sir, that's what I'm saying, sir. Even despite giving evidence, documentary evidence, it was a start question answered by the Minister of Civil Aviation saying, yes, we did this, we violated this statutory norm, and it has caused a loss of 300 crores. Despite which the magistrate says, no, you didn't make specific allegation, so I'll send it for 200. Now it will go for 200, the police will sit on it for months together. The accused will come and say, no, he's a disgruntled element. Now, where is this going to end? And can we rely on the police report? Now, second thing is under 200 and 202. If 156.3 is converted to 200, now the law of jurisprudence is being laid on the head. A police officer who did not file the FIR is going to sit on judgment about his own matter. So where is this leading to? So the conundrum is like whether the chicken came first or the egg came first is going to be there for the rest of our lives. And I really thank Justice Shrikrishna for coming up with what we has come up today. And this debate has been a churning experience for all of us. We all gave our views. And I thank this platform once again for bringing in legal luminaries, nice persons, and persons who can give us good information. And this platform for adjudication, and the debate that we are having today is such a healthy one, which rarely any platform accords to any one of us. And I thank everybody for participating, and I thank Justice Shrikrishna once again for all that he has enlightened us with. Thank you very much.
Permission, can I make one doubt? Yes. So, regarding the power of the SHO under section 156(1), Nobody has any confusion. So my question is whether by an order issued under section 156(3), can the SHO be made to do something other than what he could do even without such permission?
That is why, Dilip sir, it's called a preemptory order, no sir. That since he didn't do his job in the first place, he's being reminded to do.
No, my question is on another premise. I say that the investigating officer is enabled or statutorily empowered to do investigation under section 156(1). Yes. His power is not challenged or he has not undergone any discussion or any.
156(1) is jurisdiction. It is jurisdiction.
No. He also has power to investigate.
Correct.
Correct. File 154, sir.
But there the expression is may. Police officer may.
Yes. So it may investigate into a cognizable offence, provided the jurisdictional aspect is there, because the court should have jurisdiction to inquire and try. My question is, what he does by himself can be done by with the permission of the court also, or order of the court also. That is what 153 says, according to me.
Yes.
Once there is an order under 153, he cannot say that I will not register an FIR. Even if I register an FIR, I should have reason to suspect the commission of an offence. He cannot say. He has to register an FIR, or the complaint itself will get itself converted into an FIR, and he has to come and enter on investigation.
So the court 156(3) says that the court shall direct or
for investigation.
Dilip sir, may I interject for a minute?
Answer.
We are restricting our topic to 156(1) and 156(3). But don't forget, we come to
No. My only doubt is, may order such an investigation as above mentioned.
That's investigation under 156(1).
156(1). So, can by an order of the court, can the SHO be expected to do something other than what he would have done under section 154?
In the normal course is your question. Will the can the SHO be directed to do something which he would not have done in the normal course?
Yes. That is what I want.
Now please see 156 and 156 a kind of check and balance. Now 156(1) is the IO. He refuses or he escapes making an effective investigation. The aggrieved person, he is not left without a proper remedy. His remedy lies in 156(3).
And 153 also magistrate may order. But once it is ordered, SHO has no discretion. He has to register an FIR and enter on investigation. And that should end in a final report.
I said,
good or bad.
Such investigation as above mentioned.
Yes. That is the jurisdiction. He has got the jurisdiction to conduct investigation. He may conduct investigation, may not conduct investigation. But once the magistrate also may order, may not order. Once the magistrate orders, the SHO cannot say that under 157 I have got the discretion to enter on investigation or not. No. He has, because it is sent for investigation, not for merely registering an FIR. Therefore, he has to register an FIR and conduct an investigation. That should end in a final report under 173(2), whether refer report or charge sheet.
Dilip sir.
Am I right? Am I right?
Absolutely.
Dilip sir, you are coming to 156(1), but you are forgetting that 156(1) would apply when 154 and 154(3) also are not complied. We can only when he doesn't do his job under 154(1), 154(3), then only I come to 156(3). I don't come directly to 156(3). So when 154(1) is there, he is supposed to conduct the investigation. Since he has not done that, I have to come under 156(3) before the magistrate. I am compelled to come.
And that is why the Supreme Court has often observed that even while ordering a 156(3), direction for forwarding it for police investigation, the magistrate shall not be a post office.
Correct.
Also, actually, application.
Apply his mind. Yes.
Yes. Yes. So, sir, what he has to apply his mind, whether the act constitute a cognizable offense.
Absolutely.
Not only that, I will add one test. Magistrate will have to examine whether there was a police investigation into the allegation. He will find out whether there was an investigation by the police. If there was no investigation, why?
Why?
That should always that should be the first test to be applied. There might be a case where the party doesn't have any faith in the police, in
Correct.
which case it will be an exercise in futility to order police investigation. Therefore, magistrate will have to first find out from the party. This is a case where I am convinced that this matter should be forwarded under 153. Was there any police investigation in the matter? The client says no. Why? I don't have faith in them because I had approached them. There is, in fact, one of the accused is hand in glove with the accused. Therefore, I have no faith in the police. All right, magistrate can straight away order 153 investigation under 153. That will be a fit case. So these are the criterion which though not mentioned in the statute, which is reasonable magistrate will apply.
Correct. And to avoid these frivolous complaints also, sir, that is why Priyanka Srivastava said, let him file an affidavit so he's held liable to the statements that he's making.
That is only when the party wants a 153 order. But if the court is so much ordering it, no affidavit.
No affidavit. So that brings us to the end of this particular
unending discussion.
And we got a lot of reading. Anyway, thank you so much, sir, for the pain you have taken to do the research. So till we meet Saturday. Goodbye.
Goodbye and good night.
Thanks.
Thank God we don't have to say good morning.